preliminary hearing.
I understand, Your Honor.
All right, that part of yesterday's hearing to set the rules of the road for the prelim starting on Monday. Let's bring in our guest for the hour, criminal defense attorney Jessica Mishali. Jessica, happy Thursday to you. The prelims, different states have different mechanisms to go to trial, and in this case, we're going to get a pretty good look at the state's evidence in this case during this 3-day preliminary hearing. You're not going to have all the witnesses come in because, officers can come in and talk about what they did. But that said, pretty safe to say we'll get a much better feeling of the strength of the case.
Absolutely. I mean, from what it looks like right now, the judge is getting into really the details, even of what witnesses are going to be saying, which usually we don't know that until you're in trial. Of course, there are certain subjects that are handled in advance, what might not be admissible, what you don't want the jury to ever hear. But majority you're hearing for the first time at trial. When you're doing a 3-day hearing like this, it sounds like us as the public watching this are going to pretty much learn everything that's going to be learned at trial.
Yeah, the bar is pretty low to for the state to get over the bar to send it to trial. However, they still do have to establish their case in front of the judge, and we'll be there for every minute of it. Let's get a break in here. We'll go back into that courtroom and pick up some more of yesterday's hearing, setting the rules of the road for next week. Stay with us.
Join Court TV's Vinny Politan.
In every story, in every trial, every case, there's at least 2 sides to it.
To dive into the latest.
Oh my God.
And breaking true crime stories.
This was a very targeted, very personal attack.
Inside.
I've never seen that in a discovery. I've been incarcerated 3 years.
And outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinny Politan Investigates. Tonight, 9/8 Central. Only on Court TV.
The Hut.
Court TV Live, we're going to head back to Utah now, pick up Wednesday's hearing in the Kouri Richins case. This was a virtual hearing. The defendant was listening but did not appear on camera. She will be there on Monday for the preliminary hearing, though. Here's more from that hearing. The defense pushing back on possible hearsay statements that they say should be used or could be used by the state. They don't want them at trial.
I think that brings us to the 1102 statements of, I'm going to get the initials wrong here, forgive me.
CL and HJ.
Let's handle HJ first. That's the short one, right?
Yes.
Ms. Nestor, what is the defense's concerns regarding the reliability or admissibility of the proposed 1102 from HJ?
Your Honor, as the court is aware, under Rule 7B of the Utah Rules of Criminal Procedure, the state is authorized to use in whole or in part what is called reliable hearsay. And, the entire statement is hearsay because it's made by a declarant who's out of court. Then Rule 1102 gives us some guidance as to what the definition of reliable hearsay is and gives us a list of what types of statements are considered reliable hearsay for purposes of Rule 7B. And we do not believe that the statement by HJ meets any of those. And just real quickly zoom through them, the first would be whether it would be hearsay admissible at trial. Obviously, this is just a classic hearsay statement. It would not be admissible at trial. It also would allow...
May I stop you there for a second?
Yes, Your Honor.
If we can go one at a time. HJ's out of court statement might not be, but Ms. Richins' out of court statements, why wouldn't they be categorically non-hearsay as an admission of a party opponent?
Hers, I think, would be, but his statement would not be. So I'm basing it on his statement.
Understood.
because without his statement around it, the context, it doesn't really make any sense. The second ground would be hearsay that would otherwise be admissible for an unavailable witness under Rule 804. But under Rule 1102, admissibility is a non-factor. It doesn't matter. So in other words, whether if someone made former testimony under oath, which this is not that, if it's a statement under belief of an imminent death, I believe HJ is still with us and did not believe he was under fear of imminent death. A statement against interest, again, doesn't apply, or a statement of personal or family history doesn't apply. So that exception or that definition of reliable hearsay does not apply. The other one would be if it has something to do with laying a foundation for authenticity of a document. And Your Honor can see we've bent over backwards for purposes of this prelim. We've not challenged authenticity of any document.
May I ask you a question?
Yes, sir.
Why doesn't this qualify for admission at a preliminary hearing under Rule 1102 B8B? Just like every other 1102 statement typically comes in under B8B.
Well, Your Honor, we don't have any evidence that this was a statement that was transcribed verbatim. I guess probably the closest it would come would be number 8 would be the reason. And just for purposes of the record, I assume you're talking about a statement that's written, recorded, transcribed verbatim, and sworn or given under a notification of perjury punishment, right?
It's the latter, right? Like the opening paragraph says, I understand if I make a false statement, I'll be subject to a Class A misdemeanor. This is the language that we typically see in the preamble of 1102 statements.
Right.
Now, I'm not suggesting that immunizes everything that follows from other consideration under the hearsay rules or the reliability concerns. But if we have a witness saying under potential criminal penalty for making false statements, I had a conversation with the defendant in which she said X, Y, and Z, and I said A, B, and C. Why isn't that admissible as reliable hearsay under 1102?
Well, I think part of the reason it lacks reliability and part of the reason that we have an objection to it being considered for purposes of establishing probable cause is simply the lapse of time. So this statement was signed, I want to say 2 years after Mr. Richins' death. There is no context for why this individual allegedly remembers the date or timing or specifics of a call. And the first time he ever discusses it is 2 years later, when there's been massive publicity about this case, about the facts, about, widely available to anybody that wants to read the facts of this case. So we just feel like it lacks the normal indicia of reliability. For example, and I think this number 8 definition of reliable hearsay is more geared towards witness statements that are taken at or near the scene. In other words, when a police officer, interviews someone at the scene of a homicide and says, hey, tell us what you saw, and they sign their statement and they put their date and their name. This is not that. This is a situation where 2 years later, he hires a lawyer. He and the lawyer show up, have an interview at the county attorney's office. The county attorney then goes back into and I'm not suggesting this is improper, but this is what happened. And it happened before the law changed, which prohibited district attorneys or county attorneys from drafting the statement themselves. That law changed in February. So this all occurred before that. So I'm not suggesting any improper conduct. But what happened was the county attorney went back, listened to the interview of this gentleman, pulled out quotes from it, and put it together in a statement and sent it to the lawyer for the guy to sign. So I also think it doesn't meet the requirement of the new law that the prosecution not be the person that drafted it.
As long as all they do is create an exact transcript of recorded statements, I think it would comply with the current version of the law as well. right?
I expect that's what Mr. Bloodworth will argue, but I do feel compelled to raise it.
All right, let's bring in criminal defense attorney Jessica Mishali. You remember her? She represented Marsha Thompson right here on Court TV. Did an excellent job in that case. What are you taking away? Anything pop out to you? This back and forth with the judge and the defense attorney? It's all very important because what is decided here, if the case goes to trial, which it will, all of these rulings will be in place.
So it's kind of hard to gather exactly what they're talking about. They're using a lot of numbers and it's a different state. But I think what's clear is they're talking about hearsay statements right now, which hearsay statements are statements made by somebody outside of court, which are typically inadmissible because they're not really reliable. If one person says what another person says, it's kind of like a game of telephone and it really doesn't have a lot of reliability. So right now they're getting into particular hearsay statements, and it sounds like there's multiple witnesses that the state wants to present who could say something that the deceased, Mr. Richins, said out of court that would incriminate his wife. So it'll be interesting to see what actually becomes admissible and how harmful it is to the defense's case.
What's your overall take of this case against Kouri Richins? You had this mother, grieving mother, writes a children's book about grief, and now here she is accused. And a lot of times this happens. You've got one family saying, oh, I knew from the beginning she was bad, and then another family saying there's no way this is in her DNA. What do you take from this, from what we know now as we look forward to this moving along?
I actually think it's a really exciting and interesting case. The fact that she wrote this book and went on television and was presumably really well liked out there in the public, and she seemed very sympathetic, to then go to a situation where she's charged with murdering her husband. I think it's going to depend a lot on her. And I think that's what it comes down to in a lot of these cases. Is she going to take the stand? What's she going to say? And how is she going to justify some of this evidence that the state has against her? Are we going to believe her? Is the jury going to believe her or not? That's what it all comes down to.
Yeah, it is a fascinating case because, you know, he has what he has in his system. How did it get there? Did she poison him, or did something else happen? We'll see. It's a fascinating case. We'll get a break in here. When we come back, more from that hearing yesterday as we preview Monday's preliminary hearing in the case against Kouri Richins.
No credit hit.
This is it's a day I've been waiting for nearly 2 years. You know, this thing's been kind of a nightmare, frankly. Again, I want to thank you for being here. And right now I want to say unequivocally, I'm innocent. I didn't kill Mr. Gurman. And I've got a lot to share with you all.
He's waited 2 years, and we're going to have to wait about 2 hours because that's when Robert Tellis will be back on the stand in the case against him out in the state of Nevada. He's giving his testimony in narrative style without being asked any questions. Tellis spoke for more than an hour and a half yesterday.